I hope I have educated you better about the data the Law Society has, which has received your petition. Your petition comes from even a position of privilege. It can be written. But for the Karamojongs, we have to pick intelligence and data from conducting retreats with our staff, and we ask them, what weren't you able to do? And they say we couldn't get Karamojongs, hundreds and thousands, from the dragnet of Masholo. We don't have the resource. We don't even know where to begin. It is therefore crucial that our meeting with the Chief Justice, when it happens, and I hope he doesn't cancel it now because we have spoken. But we hope that when it happens, it should result in one thing and one thing only, a judgment date in the Kavaziguruka appeal. He was giving an interview in the Monitor recently, and he said the characteristic of justice is to act without fear. But why does he fear? Isn't this fear? One wonders, what do the Supreme Court judges fear? Why are they pussyfooting, dilly-dallying? From the International Bar Association, the Human Rights Institute. And we have received similar calls from the Regional Bar Association, the East Africa Law Society, and concerns. I am in communication almost daily with the President and Vice President of the Society of Kenya to ensure the safety of their colleagues who are performing in Uganda. Behind Honorable Martha Karua, I understand there's a team of jurists, not only from Kenya, but across the world. And the proceedings at the General Court Martial have been of great concern for the International Commission of Jurists, which is housed in Kenya, the Kenya chapter. So this is not the only petition the society has received, and we are open to receive more petitions, and we assure the public that we will give these petitions treatment, the rightful treatment they deserve. Colleagues, on some day which is still being discussed, someday soon, possibly this month, I believe next week, I will lead a delegation, a high-level delegation of the Uganda Law Society. You remember the words of Rule 10? Yes. Come and educate the public. It's not for lawyers. Yes.
It says where there is urgency, they invoke Rule 10 and leave.
No urgency. Where there is constitutional
Where there is no constitutional business, they leave all other businesses and attend to that constitutional matter in that regard.
Including sitting on public holidays.
Sitting on weekends, public holidays, even at night, as they did in Mbale.
Yes. And who took us to Mbale? Chief Justice Owinidoro, when he was Deputy Chief Justice. So contrary to all these clear rules, we submit, colleagues, that the Chief Justice has sincerely failed to ensure that his colleagues on the Kavaziguruka decision, the Kavaziguruka quorum, comply with Canon 6.2 of the Uganda Code of Judicial Conduct. And this has undermined the principles of fairness, of justice. Justice must not be delayed. Justice must be speedy. Finality of litigation. We are talking of 25 years, 42 justices of the Supreme Court and Court of Appeal, reaching endless and chaotic decisions on just one provision, the PDF Act. The ordinary citizen is confused. Is Uganda incapable of pronouncing with clarity the laws Parliament has written, the Constitution it made for itself? Why do we pay these people? Why do we continue to pay them if they cannot serve us the sole product and service we want from them, justice? Now, we are aware that the justices of the Court of Appeal and the Supreme Court are in retreat in Mbarara, where they have been since Monday the 13th, and they will be there until tomorrow the 17th, to discuss appellate court business, I would presume, and welfare, of course. But I hope one of them has raised the issue that they are in breach. They are in breach of a cardinal duty to resolve the Kabaziguruka appeal promptly, now that the public honestly has reached breaking point. The public's patience has reached breaking point. It is my humble submission, colleagues, that we have reached a point where open, relentless, and severe criticism of Chief Justice Owini Doro and his Supreme Court can no longer be avoided. Their curious and culpable delay on the Kabaziguruka appeal alone has eroded and continues to erode trust in the judiciary, perpetuating a culture of impunity and disregard for the rule of law. Due to their delay in delivering this judgment, our Supreme Court luminaries are now perceived as enablers of military repression of political opponents, stifling dissent and perpetuating a culture of fear. Why don't they listen to what the public thinks of them now? Isn't that a breach of Article 126, Sub-Article 1, that they sit in those offices in our name and they perform their duties based on our trust? So our perceptions of their fidelity matters. And today, I hope we have used the clear words to deliver the message while they are in retreat. For the sake of vulnerable communities like those in Karamoja, who are at the clear and present risk of continued military incursions into their homes and farmyards, for the sake of the Karamajongs, because that's what they call them in Chitalia. Mariam, come here. Is that what they call them? Is that what they call general court martial suspects in Chitalia? What do they call them? They call them Karamajongs. It's colloquial now. I was there. I went to see Aaron. And I heard it. They call them Karamajongs. It's normal. those Karamojongs. A general had visited to conduct pardon proceedings. It's now normal. For them, lawyers don't see them. There's no need. We had a retreat last week with our teams from that area. Kabong, Abim, yes, help me. Kabong, Moyo, and Arua. Yeah, but the Kabong team was able to tell us what happens in that area. And they told us, we use a different method with the General Court Martial and the Karamoja situation. We achieve more in this manner. So, my Lord Justice of Appeal, Justice of the Supreme Court, this is the feedback. Ugandans have found a way of finding justice when confronted with the dilemma of martial law, and it doesn't include waiting for you. Olivia Rutaya did not wait for you. She waited, and 4 years was enough. She took matters into her own hands. She invoked her own agency. And many others. So we urge the Supreme Court, for the sake of Karamoja at least, which has the most number of victims, they are in tens of thousands presently. If we count the cost of 2,000, because these things, they call it what? These expeditions began in 2002. Dr. Honoria wrote a report on it, I remember. Disarmament, they call them. Disarmament campaigns. They began in Karamoja. We have never done, okay, now maybe I was educated by the Legal Aid Project, that they deal with the picking up the pieces of a disarmament campaign. So, for the sake of Karamoja at least, please, the Supreme Court, you must act with urgency and some humanity to deliver this long overdue judgment in Attorney General versus Michael Kabaziguruka. You may hate Besigye and you may hate Lukwago. That's okay. You may hate Martha Karua. That's okay. But those kids in Karamoja are just children. They're just children. They're just children. They have never been to Kampala except to see the court martial. Except to see the court martial. And the person who should be protecting them, their own, sits back and watches. I received numerous calls from people I didn't know when I was on sick leave, telling me, don't they apologize. We are defending you. We are telling her, my name is so and so. I am her nephew. I am her niece. What did she do? Don't dare apologize. If you dare apologize, you are a hero in Karamoja, Isaac. They were telling me, absolute strangers. We have a crisis in Karamoja, and it is wrapped up in Kabaziguruka. I hope I have educated you better about the data the Law Society has, which has received your petition. Your petition comes from even a position of privilege. It can be written. But for the Karamojongs, we have to pick intelligence and data from conducting retreats with our staff, and we ask them, what weren't you able to do? And they say we couldn't get Karamojongs, hundreds and thousands, from the dragnet of martial law. We don't have the resource. We don't even know where to begin. It is therefore crucial that our meeting with the Chief Justice, when it happens, and I hope he doesn't cancel it now because we have spoken. But we hope that when it happens, it should result in one thing and one thing only, a judgment date in the Kavaziguruka appeal. He was giving an interview in the Monitor recently, and he said the characteristic of justice is to act without fear. But why does he fear? Isn't this fear? One wonders, what do the Supreme Court judges fear? Why are they pussyfooting, dilly-dallying? And whispering over the Kavaziguruka decision? It is crucial that if or when our meeting with the Chief Justice happens, it should result in a judgment date to arrest public anger and curb long-term harm to our judiciary. We can't take 25 years and employ 42 justices of the Court of Appeal and the Supreme Court to arrive at an unclear result on the interpretation of Section 119, subsection 1G and H, vis-a-vis its conformity with Articles 28 sub-article 1, 126 sub-article 1, and 210 of the Constitution. That's a question students use 2 hours, 40 minutes at LLB level to resolve. Why do judges think they need countless hours? This question can be resolved, and students are marked for proficiency in constitutional law, LLB 1 and LLB 2, within 45 minutes. But the judges of Uganda, 45 of them need 25 years. And a senior lawyer like Mr. Lukwabo tells you that's not enough. You need banging of tables to get them to do their work. What do these retreats benefit them? And why do they lock us out from those retreats? This is why we scheduled our first R&B at this point, so that we force ourselves into their retreat. They hear our voices. You may be in Mbarara, but we are addressing you now. Discuss this issue today or tomorrow, or return on Monday to face us. We are ready for you as well, Dolo. We are ready. We call upon the Supreme Court, and they are good judges. We call upon the Supreme Court who do not have the pulpit the Chief Justice has. We call upon the remaining 6 to overwhelm Justice Dolo, Chief Justice Dolo. Overwhelm him and say that for you already. Step out of the prison you're in. If the Supreme Court has become a prison, step out of it. We are here to protect you. There's an international community of justices and jurists to protect you. Every justice we have mentioned, you have a duty to tell us that for you, you're ready. We don't care which way you rule. We just want your judgment. Yesterday. Please, we call upon you to find time as a quorum or as a Supreme Court. Find time for another retreat between January 20th and the 31st of January this year to put a stop to this culpable delay and fix a historical wrong that has undermined the legitimacy of our judiciary and the entire legal system. Why should the General Court Martial reconvene on the 3rd of February this year, when the judges will be beginning yet another retreat? Without having received guidance of the Supreme Court, what will they be retreating about? Who will they be retreating as? Because if you don't do justice, why do you accept the title? Colleagues, that's the end of my speech.